And I would like to point out initially that we all know the reason why that kind of meeting are useful, those meetings are useful. But whenever you participate in one and you see that we have common problems, this is so comforting because, well, it's not just me, someone is worse. So this gives some sort of comfort. And after all, despite all the differences, economic differences, social differences, the differences in our legal frameworks, the problems are quite the same. So we can benefit from each other's experiences and ideas. And that's what we've been seeing here throughout the whole day. During the morning, a lot of the ideas were very challenging for me. So let me go through my presentation. Deference is our core subject today. I shall move away a little bit from the chevron pattern. It's not going to be a 2-steps presentation, it's going to be a 3-steps presentation. I will speak a little bit about, try to establish context in benefit of our foreign esteemed colleagues, and so speak a little bit about the constitutional history and the constitutional framework in which relates directly with the deference in judicial control. I'll try to establish a little bit of dialogue between the already shown abstracts. Ricardo was kind enough to share them with us before the meeting, so I had the opportunity to see how the ideas linked themselves. And the third step would be the content of a proposition of deference in the Brazilian system in which I'm working. Well, so a little bit about the Brazilian Constitution and the Brazilian contexts. Historical background first. We've been through arbitrary regimes. So authoritarianism was not an unknown concept in Brazil. We have it with President Getúlio Vargas in the 30s, and we've been through military dictatorship, which endures for 30 years, about 30 years, and we were finishing that moment when the National Constituent Assembly took place in Brazil. So the Constitution came in that context, the twilight of a military dictatorship, and an aspiration that we can bring social change through a new constitutional framework. And at the point, we have a lot of work in Brazil in which it's pointed that the progressive forces which were present in the National Constituent Assembly believe that a huge list of fundamental rights will be the path to that social transformation. So let's set a lot of fundamental rights in the Constitution. They will be at least an agenda to the development, so the legislative power will be called to develop those rights, and then we will achieve the social transformation that we wanted. At these days, before the new constitution, judicial deference as a blockage to any kind of judicial analysis came handy. It was a very good idea. So let's say that any kind of administrative decision is protected by deference, and you judges, you don't have anything to say about this because the authoritarianism was in place. So it was very useful to deal and encompass the concept of deference. So at this time, administrative choices should be upheld simply because they were developed and delivered. They came from the executive. So deference was applied in that understanding as a complete blockage of any kind of judicial scrutiny. Surely you might examine aspects which was directly addressed by law, just like competency of the agent, but it was a very narrow spectrum in which the judiciary could enter. The counter-argument at the time was strict legality. So at the time, claiming for strict legality as the frame to any kind of an administrative action was very important, because it was some kind of way that we have to stop bad decisions coming from authoritarian authorities. So at the time, strict legality was a discourse, was a narrative which intend to protect liberty. Well, but then came the 1988 Constitution, and there are some features which I want to stress that explain somehow our current situation. First, we have founding values and fundamental objectives established in the Constitution from the very beginning. In Article 1st and 3rd, you have fundamental values and fundamental objectives, just like protecting human dignity, valuing labor, assuring equality, regional equality throughout the whole country, things like this. So with that kind of valorative commitment, the idea that some kind of decision coming from the administration should be upheld simply because it's the administration's decision was not possible anymore, because the administration was addressed, was direct by those valorative commitments. A second manifestation of those valorative commitments is the very, very huge list of fundamental rights. And our fundamental rights, they are expressly provided with immediate application. We have a constitutional clause that provides immediate application to all those fundamental rights. And here in Brazil, throughout the doctrinal development, immediate application became immediate efficacy, which is very relevant, because immediate application is a concept that dialogues with the time. So you're supposed to do something about those rights now because they are immediately applicable. But when you think about immediate efficacy, there's some kind of content, a value content that enters in the discussion. So changing the discourse from immediate application to immediate efficacy was a very relevant aspect that will lead to the situation that we have nowadays. We should take into account also that huge list. We have more than 70 fundamental rights, 70, that's it. Every time I say it, I've mentioned it in English, I know that people can think that they are lost in translation. Did she say really so? Yeah, 70. And surely that constitutional framework creates a lot of pressure to the legislative and the executive power, because those rights are there, they are provided with immediate application. So come on guys, you're supposed to do something. Due to the immediate application clause, even if there is no legal provision about that right, you're entitled to file a lawsuit, because those rights are provided with immediate application. So we have, for instance, in Article 6, a right to leisure, a fundamental right to leisure. So someone can file a lawsuit and say, well, where's my right to leisure? We have a right to transportation. We have a right to housing, which is my day-to-day subject. I represent Rio de Janeiro City Hall, and I am specialized in lawsuits involving the right to housing. So the right to housing, for instance, it do not have legislative development. You have here and there public policies addressing some part of the problem, but you don't have broader legislation, establishing things like who are the beneficiaries of such a right to housing, what kind of obligations, concrete obligations came from the right to housing. So this is the reason why we have that huge amount of lawsuits, because you have the extensive list of rights, you have the immediate application clause, and you don't even need to wait to the legislative, to the parliament to address the problem. And this somehow facilitates legislative inertia, because if people can claim their rights directly through the judiciary, why should I decide that if you are more than 25 years old, you're not entitled to special protection in this or that? Why should I say that the right to housing is destined only to people with which earn up to $1,000? Why should I feel that support that burden of deciding and bringing insatisfaction from someone if I can simply not decide and let those people claim through the judiciary? So this is something that our system was. So that context amplifies administrative regulation, because if you're supposed to do something, if you can be called by a judge to do something, the right to housing, so let's try at least, and there's no law in the matter, so let's try at least to establish some kind of administrative regulation. So that context amplifies administrative regulation in fundamental rights. And the last element, last but not least component, it's our granting of access to justice and the institutional apparatus that come with it. So our Constitution has also access to justice as a fundamental right, and this is being understood in a very, 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 sorry for the judges, they are here, but in a very, 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 very broad sense. So yeah, they know me. I'm not a judge. I represent the administration, so they know that we have that disagreement. Let's agree to disagree. And academia provides this, so this is wonderful. This is my opportunity to say this. Well, so we have the grant of access to justice, and we have an institutional apparatus that grants this. So you have a very strong judiciary powers, and you can find judges in a very fair number, in a very fair geographical distribution, and you also have the Public Defender's Office, which will provide legal representation without any fee, any cost. And the eventual lawsuits that you propose will also be held without any fee, any cost. So this somehow also stimulates new lawsuits, because what can I lose? Nothing. I will go to the Public Defender's Office and say, well, I think I deserve, considering that there's a right to leisure, I think that I deserve a ticket to go to the cinema, to the movies once a month. Well, but this is not already regulated. But can I file a lawsuit about this? Yes, you can. So let's do it. Sorry, you lost. No problem. I didn't spend a single real, so no problem. So this is the framework that brings us to that discussion. And what about deference? What about deference? Well, deference arrives in that context with a very negative semantic charge, because deference was the tool in the authoritarian period. And we're not in an authoritarian period anymore. We're in a democratic period. So deference was seen as an undue blockage of judicial scrutiny. And in a democratic ambience, we cannot accept power decisions exempt of any kind of judicial control. So the very idea of deference came with a very negative perception. We should also take into account also that access to justice in that constitutional framework will allow the control of an existing decision. So the administration took a decision, I disagree, and I think it's unconstitutional, illegal. So this is a possibility, but you can also file a lawsuit whenever you have a lack of decision. So administration didn't decide yet, and that idea of a lack of decision can be presented even in situations in which you don't have a public policy in the matter, because the public administration simply think that you should not have a public policy in that matter. Because drafting public policy can also encompass the decision that that kind of issue will not be considered in my public policy. So all these hypotheses can be brought through lawsuits.